Right. Hopefully you can now see us all. I'm Michael Singleton, head of the Housing and Property Group in St Ives Chambers. Today's speakers are David Nuttall, he's the chap with the beard and the sandy hair, and Harry Marriott, who is on my monitor at least on the lower screen, looking like the losing team in University Challenge with the glasses on. Welcome to the 2021 Housing Conference. This is the second one that's been done in virtual format. I wonder why. A slight departure from last year. This is being done as a webinar rather than a large meeting. The reason for that is, as always, technology. The large meeting format, which I like because you can see who's looking at you, and you can also make faces at them, only deals with about 100 people. This year we have 200 plus delegates. It was at 211 when Ross last checked. When we were doing this in person in a physical venue 2 years ago, we would get around about 60 to 70 people. So 60 to 200, not bad. By 2025, we will be playing stadiums. The downsides of it not being a physical conference are you can't take the day off, or at least you can, but you don't have to get your employer's permission perhaps now, and we can't hand out freebies. By way of amelioration for the lack of freebies, this is being recorded and all being well will be available for download from Chambers' website. One thing that's always asked is, can we have copies of the notes and the slides? What Ross is going to do is collate all three sessions, so the one next week and the final session the week after, which has a stellar array of speakers, including me, will be put together as a single package and forwarded to you all. So rather than have what would be over 600 emails going out if we did it each time, hopefully we'll have just over 200 going out. A few technical details. I've been forbidden from wearing a hat this year, so I'm not happy. There will be no subliminals, so anybody who thinks they're being told send us some work or please check your age, debt and pay council, wasn't us, Gov. This deals with the perennial subject of disrepair. David will be speaking first, followed by Harry. If you've got questions, please submit them by the chat function. Hopefully, one of our newest members of Chambers, Queenie Jan, will be collating those and passing them to the speakers. I'd ask you to leave it till the very end, because what tends to happen or can happen is the question comes in, diverts the speaker. If myself or Harry want to chip in and it's David, there's then a 5-minute discussion where we all politely disagree with each other. So if that's the case, if you could just leave it till the end. If, however, there is something burningly urgent, like my video's gone off, to which the technical advice will, as always, be turn it off and turn it back on again, please let us know meantime. Right, I think on that basis, I will now hand over to David Nuttall.
Michael, thank you very much. I'm just going to share my screen to start this presentation going. Right, there we go. Harry's going to give me a thumbs up if that's working. Excellent. For those of you who don't know me, my name's David Nuttall. I have been a member of Chambers since 2012, called in 2010. I did my pupillage here. I have from essentially the start specialised in housing and what would become known as business and property work. So very much from a property point of view, I approach all of my cases. And what I want to be looking at particularly today is bringing in some of those property concepts, real property concepts, into housing disrepair, which can sometimes seem like a little bit of its own niche area with its own rules and its own law. But of course it's not. It's a part of property law, and that's what I want to be looking at today. Now, I'm going to be dealing with these substantive elements. Harry afterwards is going to be looking more at the procedural side of things. He's going to be looking at the pre-action protocol and costs and maximising prospects of success from the earliest possible stage. He's going to be telling you how to say things. I'm going to be telling you what to say. My talk is split into two main areas. The first is section 11 and the meaning of structure of properties. And the second part is going to be completely unrelated to that, nuisance and third-party claims. And you'll see how I do try to link those together a little bit going forward. But the focus is really on these slightly trickier, more complicated areas that can sometimes create stumbling blocks on both sides. Now, full disclosure, the absolutely vast majority of the work I do, particularly in disrepair, section 11 disrepair at least, is from a landlord's point of view. But I am going to present this in a way which is hopefully of assistance to both sides, with a view to both bringing and defending disrepair claims in the strongest possible way. So, starting with section 11 and the structure of the property, I'm going to be looking here at, first of all, the meaning of simply the word structure, and particularly in a damp context, because that's the most common type of defect that we see in these cases. Second, the meaning of exterior, and when structure of the dwelling house means actually the exterior of the dwelling house, and more importantly, perhaps when it doesn't. And third, design defects, and when these can amount to actionable disrepair. So let's imagine that we are either in the process of drafting or we have received a letter of claim along these lines. Very common matters here that you see every day in letters of claim and then the attendant claims themselves. So let's say that we've got an allegation of damp and mold growth in the living room, which is causing degraded wallpaper, and that, it is said, is being caused by a defective damp-proof course, and so therefore it's presumably some kind of rising damp. Second, that we have condensation damp in the kitchen, which is causing some kind of problems with the plasterwork. Third, that we have damp in the bathroom being caused by a leak in the roof. And fourth, that we have some sort of damage to an external lean-to structure outside of the house itself. Now, bear in mind those points because I'm going to be coming back to them. I'm not going to work through this now. I'm going to go through various concepts and then wrap this part of the talk up with what I would say is the answer to all four of those allegations. From the landlord's point of view, from the tenant's point of view, it will be very much how they could be presented in a way that will give them more weight. So just as a recap, section 11 itself should be well known to everyone. The main point is, of course, section 11(1)(a), which is that the obligation on landlords in short tenancies is to keep in repair the structure and exterior of the dwelling house, including drains, gutters, and external pipes. I'm not going to talk about B and C, but a lot of what's being said will cover those as well. But the real focus here is on structure because that makes up 90% of all of these claims. So what does structure actually mean? you'll see a lot of these cases that I'm going to talk about come from outside of a housing context. A lot of them come from either a commercial context or they will come from a context of housing cases, but from long before the modern Housing and Landlord and Tenant Acts. And so a lot of these are more focused on express terms in tenancy agreements. But here we have Irving's Estate and Moran. It's a first instance decision. It was in front of a recorder. So on its own, it doesn't have a huge amount of impact, but I'll come back to why it is important and frankly binding, I would say. The importance of Irving's Estate and Moran is that it is a fairly extensive description of what the word structure means in a housing context. I'll give you a second to read through that, but you'll see that structure includes things like the windows and everything associated with windows, external doors, obviously the walls, the roof, things like that. The more important part of Irving's Estate and Moran is what structure does not include. It doesn't include decorations. It doesn't include wallpaper. It doesn't include things which are for the purpose of fitting out and equipping the property. So it doesn't include kitchen units. It doesn't include built-in wardrobes. It seems there's a case called Langham Estate Management and Hardy, where a High Court judge determined that internal doors didn't fall within the meaning of structure, and that seems to follow the guidance in Irving's Estate and Moran. Question mark over whether or not that's in any sense binding, because I think the point in that it would also throw open some curious questions, such as does a stud wall count as structure if it has nothing, no load-bearing quality whatsoever. But in any event, internal doors notwithstanding, pretty clear what falls in and outside of that meaning, and it is quite a restrictive definition that's being provided there. In that case, I should say, the judge included plaster in the exclusion part of it all. And as we know from what will follow, plaster is, of course, now part of the structure. So on that note, move forward to Grand and Gill. So this was a case that was dealing primarily with whether or not plaster was part of the structure. Everyone remembers it for that reason, that Grand and Gill is the case that says definitively plaster is part of the structure of the property. I say that one of the more important parts of Grand and Gill is the first few lines of the extract there, which is that the observations in Irving's Estate and Moran are accepted by the court in Grand and Gill and are accepted as a good working definition of the word. So on the one hand, whilst Grand and Gill expands the definition of structure to include plasterwork of a property, on the other hand, it approves a very much more restrictive definition of the word, which needs to be borne in mind. So in terms of damp then, and section 11, the key point is that you can separate damp cases out into, well, 3 categories. The first category are the completely unspecified claims of damp, which simply aren't actionable. But then the other 2 are where it can be. So of those 2, the first is what I might describe as damp being a symptom of actionable disrepair. So where there's some sort of structural defect in the property. So one of the types of structure that was defined in Irving's Estate and Moran has become defective and is in disrepair. Where that defect causes damp, that damp will be actionable, or rather the underlying defect is actionable, but the damp is a symptom of it, and therefore you'll be able to claim damages. Tenant will be able to claim damages for that damp. So an example of that would be a hole in the roof or something like that. Something that's allowed water penetration, which has caused damp, or maybe where a pipe in the bathroom or something has started to leak, and it brings in section 11(1)(b), and as such we have actionable disrepair. Then the damp, which is a symptom of that, will be part of the defect for which the landlord's liable. The second type of damp which can be actionable is not symptomatic of anything. It is the cause of some kind of structural disrepair. So this is generally condensation damp. So the condensation isn't being caused by any problem with the property. It's just there in the air, and the property is not being ventilated properly for some reason, either due to its design or due to the tenant's lifestyle. And where that damp has then gone on to cause a Section 11 defect, such as damage to the plaster or rotting timbers or something like that, then the damp will be, again, actionable. But it's not actually the damp which is the thing that the landlord is liable for. It is the damage that the damp has caused. That's a very important distinction. So it's not the end of the story, just simply proving that one of those two categories of damp disrepair have arisen. It's important for a court to work out which one of the two it is, because it's going to have a very important impact on the damages that are awarded. If it's the first of those two, then the damages that are going to be awarded are all of the damages that flow from the underlying defect. So if it's, say, a hole in the roof, then that is what the landlord is liable for. But then the damages that become payable are for all of the effects of the hole in the roof. So if the hole in the roof is causing damp, and that damp is causing the property to be cold, the property to smell, damage to the tenant's possessions, all of that is going to sound in damages, the whole lot. So where the damp is symptomatic of something, it generally means that we're going to be looking at considerably higher damages than where the damp is causing some sort of structural defect. So with that second category of damp disrepair, where the thing that the landlord's liable for, again, isn't the damp, but it's what the damp is causing, so a damage to, say, plaster or some rotting timbers, the thing that the landlord is liable for, the thing that the landlord is going to pay damages for, is that defect, the thing that the damp has caused. So you might have the worst damp anyone's ever seen. It might make a room pretty much uninhabitable. I put fitness for human habitation to one side for all of this. You might have horrendous damp. But if the effect of it is simply to cause some blistering of the plaster in one corner of the room, the landlord's not liable in those circumstances in terms of damages for all of that horrendous effect on the room. The landlord's liable for the cosmetic effect of that corner of damaged plaster. So a hugely important distinction, and one that I've dealt with in many trials, that is the difference between thousands upon thousands of pounds worth of damages and essentially something nominal, or just the claim being dismissed because it's because it was de minimis. So a really important point to always bear in mind, and from either side's point of view, something to grapple with early on to work out which of these it falls into. So of course, from a landlord's point of view, even if there is horrendous damp, the offer that's going to be made, even if liability is accepted because some plaster damage has occurred, the offer that's going to be made is going to be dictated by which one of these two the damp falls into. So moving on now to the exterior of the property, and we have the famous Kumarasamy case, which dealt with whether a path leading to a property classed as the exterior. There had been a lot of argument one way and the other about whether damage and defects to simply the wider curtilage of the property would be sufficient to bring in Section 11. And the Supreme Court on this, although it wasn't 100% on point, it's pretty clear that it wouldn't. The key point is that you're looking at this from would a reasonable person say, in the context of Section 11, would a reasonable person say that if the front path to a house is uneven or has become damaged or something like that, would a reasonable person say that the exterior of the dwelling house has become defective? And the answer from Kumarasamy is that generally no. Exterior means what it means, that the outside of the house, the outside structure really is what we're looking at here. So we're looking at the walls, we're looking at the roof, we're looking at the front door, we're looking at the exterior of the windows, but nothing further than that. And that, of course, is important in cases with older properties where you might have lean-tos or outhouses and sheds and all sorts of things like that, or indeed walls and paths. Of course, the express terms of a tenancy agreement, usually in social housing, would incorporate a repairing obligation on the landlord for these exterior parts, these other exterior parts. But in terms of pure Section 11, I would be arguing that if this came up, I would be arguing that it doesn't fall into it. So next on structure, we have design defects. Now this is a common issue, and Quick and Taff-Ely is an important case, because in that case, the issue was, one of the major causes of the issue was cold bridging. So this is where, because of the design of the building, it allowed the structural walls of the property to develop cold spots, which then in turn caused horrendous damp. And the question is, whilst in circumstances where that design of the building is causing a horrendous loss of amenity to the tenant, is that enough to bring in a disrepair? Is that enough to make out disrepair to the structure? And the answer is no, for hopefully clear enough reasons now. And where this comes in commonly to cases is with defective damp-proof courses. So a frequent matter I see in cases I deal with are an allegation that there's rising damp in the rooms of the property, and the cause of that, I pause to say usually without any real evidence of this, but it is said the cause of that is because the damp-proof course is defective, and so it's allowing the lower part of the walls of the property to either transmit moisture up them or to just become much colder because they're in contact with the ground, and that's because the damp-proof course is for some reason defective, or because it's being bridged in some way. So, for example, plaster or skirting board or some other part of the structure is connecting, notwithstanding the damp-proof course, connecting the wall to the colder ground. And again, that's allowing moisture transmission or cold transmission up the wall, which in turn causes damp. So the question is, in those circumstances, is that disrepair? Is that a defect? And I would say that Quick and Taff-Ely is authority for the fact that it's not a defect. It is simply a lack of amenity in the property. It's because of a way the property was built, the property that then was let in that state, that means that it's not as good as perhaps the tenant might want, but it doesn't mean that it's in disrepair. So with the damp-proof course, yeah, okay, maybe it's being bridged. Show me where it's defective. Show me where it's in a worse state than it was at some position at some previous time. Very similar to the case where there is no damp-proof course, and it's allowing, therefore, obviously rising damp into the property. Yeah, okay, that's unfortunate, but show me where the property is in a worse state than it was previously. There's no obligation in Section 11 or an express term that a landlord is going to install a damp-proof course that wasn't there before. And I would say that the bridging effect that you sometimes see is no different to that. And again, judges accept this argument, I find. There needs to be some evidence that the damp-proof course has gone wrong in some way. Same with cavity wall insulation. Often I would see arguments that the cavity wall insulation has become defective and allowed cold spots to appear on the wall. And the question then is, well, has the cavity wall insulation, was it installed properly in the first place? Was it in a better state at some point than it is now? Has it settled in some way, leaving cold spots? Is there any cavity wall insulation? Is the claim actually that there should be cavity wall insulation? There isn't. All of those things are questions, because unless the tenant is able to show that the cavity wall insulation has gone wrong, same with damp-proof course, there's no claim here. So, again, in Quick and Taffeely, the judge's conclusion was that, well, unless the damp is causing some kind of disrepair, there isn't evidence that it is being caused by disrepair, so therefore there's no claim. Now, of course, a lot of you will be familiar with the Ravenseft case and some of the successive cases following that, which are all about the fact that a landlord can be under an obligation to, for example, install a damp-proof course, to sort out bridging problems, to install cavity wall insulation. That obligation can arise where the lack of that damp-proof course or the lack of the cavity wall insulation or whatever is causing frequent actionable disrepair. So let's say, for example, a property was on a regular basis suffering from cracked plaster towards the lower part of the walls because of rising damp, because there's no damp-proof course. Well, on the one hand, the landlord's not under any obligation to install the damp-proof course, and so would be entitled to just go in every time the plaster starts degrading, hack it off, put on some new plaster, redecorate, say thank you very much and leave. And on the face of it, the landlord could do that every month if the problem keeps on arising and not face any sort of obligation to sort out the underlying issue. And what Ravenseft and the successive cases say is that that can't be right, and that actually, if it is unreasonable to expect a tenant to have to put up with patch repair jobs all the time, the court can, if it's reasonable to do so, require a landlord via a specific performance order to sort out the underlying problem, to solve the problem once and for all, even though the landlord might not be liable to actually do that work on the face of it. The important thing to remember there, though, is that that obligation to do that underlying work can only kick in if the effect of the lack of amenity, the effect of the lack of the damp-proof course, is that we are getting frequent actionable disrepair. Because if the lack of the damp-proof course, or the lack of cavity wall insulation, is simply causing condensation damp, which never actually progresses to actionable disrepair, then the claim still doesn't get off the ground. There's still nothing. The Ravenseft cases only apply where it's to stop actionable disrepair from occurring on a regular basis. So let's go back to this letter of claim that we started with and just apply some of these principles. So the first one, damp and mold growth in the living room causing degraded wallpaper. Let's pause there. That is not in of itself actionable disrepair under section 11. We do not have any kind of defect to the structure. Caused by defective damp-proof course. Okay, well, for the reasons I've been saying, that's not the same as damp being caused by a hole in the roof. Hole in the roof is easy. The roof is in a worse state than it was at the time before. If the damp-proof course is simply defective, we need to know how it's defective before this point can go anywhere. If it just was never very good, then that's not going to be enough to get off the ground. It needs to be worse than it was previously. Or if it's being bridged, tenant would need to show that the landlord had, as part of some other works, bridged the damp-proof course, or had carried out some alterations to the property and bridged it. And then you might get somewhere, potentially not under section 11, it might be under negligence, but you'd need something additional. So if all I saw in a letter of claim was that, my immediate response would be, there's nothing there. That is not an allegation of disrepair. And if I was representing a tenant, I would be wanting at that stage some kind of evidence, some kind of expert evidence to demonstrate what is it about this damp-proof course which is degraded, which is in a worse state than previously, so that we can get this off the ground. Second point, with condensation damp in the kitchen causing cracked plaster. Okay, so the condensation damp is not in of itself actionable. It is not disrepair, certainly on what we can see here. But the cracked plaster is. That would be actionable disrepair, but it is only the cracked plaster that would be. So if this is just a few hairline cracks on one of the wall, you can't really imagine that the court's going to be awarding much, because the loss of amenity caused by a couple of hairline cracks to the plaster is going to be essentially nil. If, on the other hand, the condensation was being caused by something actionable, say that one of the windows was broken, so that cold air was getting in, and that was meaning it was impossible to heat the room, and therefore condensation was an inevitable cause of that, you might get somewhere, because then the damp would be a symptom of actionable disrepair rather than a cause of it. But as it stands, you might have to accept as a landlord that there is some liability there, but that on its own is not going to get very far from the tenant's point of view. Damp in the bathroom caused by a leak in the roof. Of course, I've gone over that. That is disrepair, which is a symptom of something actionable. Again, not on its own will that bring with it any kind of particular damages. It could still be, probably not, but could still be de minimis, unless some loss of amenities being caused by the leak and by the damp, rather. Probably that's not going to be hard for the tenant to show. Damage to the roof of the lean-to. I come back to the Kumarasamy case. Depends to some extent what we mean by lean-to. If it's obviously integral to the structure of the dwelling house, then a damage to the roof of it may well be Section 11. If it is obviously a room, say an outside loo or something like that, that's just been converted into a garden store, but it's very much built into the house, that may well be structure. If it's obviously, though, just a simple structure just made out of a different material, say wood or something like that, obviously always intended to simply be a small garden store or something like that, probably wouldn't constitute structural disrepair. Of course, if the wall that it's attached to, the wall of the house that it's attached to, is in disrepair, that's a different question, and that would be actionable. So moving on then, I think that's covered a few points on structure. Now let's look at probably a more tricky situation that frequently arises, which is nuisance. So this is the sort of case where you generally get it in blocks of flats, where the claimant lives in one flat. There's been some sort of leak from the flat directly above, and that leak is causing disrepair to the claimant's flat. And the claimant sends their letter of claim, issues their claim, and says, well, Mr. Landlord owns the flat above, lets it out, it has leaked into my flat, the landlord is therefore liable. Usually, you often see that's as far as the letter of claim goes, and simply is then seeking damages for all of the effects of this leak. Often, that's as far as the particulars of claim go, and certainly as far as the evidence or expert evidence will go. And the point is, unless the tenant can go further than that, the claim's not going to succeed at trial. So let's look at an example. Not a letter of claim this time, I'm treating this as particulars of claim, where the tenant is alleging that at the beginning of the year there was a leak from the flat above. The flat above is owned by the defendant landlord. and has been let out to a third-party tenant. That leak was reported, and it simply continued. Nothing was done about it. And it continued for those 6 months, and the leak caused problems with damp. Now, I'll point out straight away that in this example, for those first 6 months, the problems were just confined to damp and mold growth, no structural damage. So for those first 6 months, if the claimant could prove that the leak was being caused by actionable disrepair, then the claimant could claim for the consequences of the damp and the mold growth. If the claimant cannot prove that the damp and mold is caused by actionable disrepair, then the claimant would need to show that the damp is causing actionable disrepair. And in this example, I'm saying it's not. It then changes later in the year, 16th of July, we say large cracks start appearing in the kitchen ceiling. Obviously, the leak's never been resolved, and it's filled up the space between the properties, which were reported, and then we have a ceiling collapse. And the way that the claimant puts the case, alongside section 11, is that the defendant is liable in nuisance. Now, we're not really told why that is, but frequently nuisance is chucked into particulars of claim, and it's simply left as a trial matter as to whether or not nuisance is made out. Now, let's just pause there. What even is nuisance? Well, nuisance is unreasonable use of land, which causes an interference with a neighbouring piece of land. That's a pretty basic explanation of what nuisance means. An example of that would be where a person's guttering leaks or something like that, and there's a cascade of water over into their neighbour's land, which is causing all sorts of problems with the neighbour's garden or something. That would be a pretty basic example of nuisance. If the first landowner was aware that that was happening and did nothing to abate it, then that would obviously be unreasonable use of their land and they'd be liable. The claimant in this example case is saying the same thing. The claimant is saying that water ingress into their flat from above is an unreasonable use of the flat above, and that is causing interference for which the flat above is liable. The question is whether the landlord is liable, and that's what we're going to look at. So I'm going to come back at the end of this and show you how I would plead the defence to this. So, with landlord and tenant cases, nuisance has its own fairly well-defined set of rules. The starting point is that to make out nuisance, the defendant has to be in control of the land which is being unreasonably used. And why that's important in a landlord and tenant case is that, of course, for there to be a tenancy, the landlord needs to have parted with possession. The tenant needs exclusive possession, and that means that the tenant also will have exclusive control over their land that they have the tenancy of. And so if we simply stick with that starting point, the landlord cannot be liable for the nuisance of his tenants. The tenant is liable. So in this example claim, the tenant above, the tenant of the flat above, could be liable for the water ingress in nuisance, but the landlord would not be. That's the classic starting point, but that's not the end point. Unfortunately for landlords, it becomes rather more complicated than that. To start with, there are classic exceptions to the starting point. The first obvious one is if the landlord has actually caused the nuisance, then he'll be liable for that and will continue to be liable for that even though he lets the property. So if the landlord, I don't know, causes damage to a flat such that a leak begins, he doesn't become immune from liability just by letting it. So that's causing and continuing. If he authorises the nuisance, that as well can bring the landlord into scope of liability. And I'll come back to examples of that in a moment. Not generally relevant for housing cases. That's more commercial, but I'll come back to an example. And that classic set of exceptions, it's been covered in many, many cases. I've cited there Smith and Scott, which makes the point. That's an interesting and potentially important case because it's an ASB case, an antisocial behaviour case, where a neighbouring landowner sued the landlord next door for the antisocial behaviour of his tenants. And the court said, well, no, because that doesn't fit into any of the three exceptions that I've set out there. Why I say that's potentially important is because I'm sure there'll be those among you who have faced potentially vexatious claims from owner-occupiers who live next door to your tenants or your client's tenants, where the owner-occupier is suing the landlord on the basis that the tenants are being noisy or dealing drugs or whatever, and maybe even saying, well, the landlord should have known that that was going to happen. Smith and Scott's a good little authority to just back that sort of claim away. Say no, unless the landlord's pretty expressly authorised that to take place or is somehow complicit in it, then you're not going to get anywhere. So just to briefly look at those three exceptions before I move more properly onto disrepair. In terms of causation, if the landlord's aware that there is a nuisance on the property when he is in control of it, so before it's let, then he's going to continue to be liable for that nuisance afterwards. And there's an example there, Sampson and Hodson Pressinger. How it works to the property whilst it was in his control before he let it, and created a terrace and roof garden. But the terrace and roof garden were constructed in such a way that when they were then used by the tenants to whom the landlord let the property, it was inevitable that it would cause noise nuisance to the people who lived below the let property. And so the landlord, whilst the property was in his control, had set up a nuisance which was going to be inevitably made out. And so the court found that the landlord remained liable. Authorization, as I've said, infrequent point in housing cases, but for this you'd be looking at the permitted user clause of any lease, and if the permitted user is something that's inevitably going to cause nuisance, then the landlord will remain liable. So a large rendering plant or something like that. It's not enough, and I've cited a case there, Rich and Basterfield, that the permitted user might cause a nuisance. It has to be inevitable. As I say, not particularly relevant here. So I said the starting point is that a landlord is not going to be, subject to caveats, not going to be liable for tenant's nuisance, but, and this is where a number of cases come into play, it is thought, and Woodfall makes this point, thought that might have a right to enter tenant's property to carry out repairs will be sufficient to give the landlord enough control for the landlord to be liable in nuisance. And so I start with a case called Nelson and Liverpool Brewery Company. I'm going to come back to this a couple of times. But this was a straightforward case. An employee of the pub was walking across a yard and a chimney pot fell on him. There was no repairing obligation on the part of the landlord, even though he was aware of the disrepair, and it was being suggested that the landlord would be liable for that, for the effect of that disrepair, notwithstanding him not having any kind of repairing obligation that had been breached. And the court said it's got to be the case that a landlord can be liable for breach of repairing obligations he owes to his tenant if that breach causes damage to a third party, then there would be some sort of duty towards that third party. Now, that sounds a lot like Section 4 of the Defective Premises Act. And if we take it back to our example case, the example particulars of claim, for this case to apply, for the landlord to be liable for the leak, the claimant would need to show that the landlord owed a duty to the tenant of the flat above to have repaired whatever was causing the leak into the claimant's property. And unless that could be shown, then the claimant would not be able to show that the landlord was in breach of a duty to the claimant. So the landlord's duty to the tenant of the flat above and the landlord's duty to the claimant went hand in hand in the same way as when you have a relevant defect under Section 4 of the DPA. There's a line of cases which I'm going to shoot through very, very quickly because I'm aware of the time, which are called the highway cases. These are cases with similar facts to Nelson and Liverpool Brewing Company, but where the property that was in disrepair was abutting a highway. So we have a number of cases where property was in disrepair and a pedestrian was then injured because of that disrepair. And the question in all of those cases is the same: is the landlord liable in circumstances where he's let out property, probably doesn't even have an express repairing obligation in any of these, and nonetheless disrepair has caused damage to a passerby. And in all of these cases, the court has said, yes, the landlord would be liable in those circumstances. So Wilczek and Marks, damage to a pedestrian, or injury to a pedestrian rather, no repairing obligations on the landlord, although the landlord did have a right to enter to carry out repairs, and he was on notice. And it was found the landlord had some sort of duty. And in fact, the landlord was liable. It was ultimately, in later cases, defined as the landlord was liable in nuisance for the disrepair of his tenant's property. A couple of other cases where that liability was strengthened in some ways. So, for example, in Ring and Cohen, the court said the landlord doesn't even need to be on notice. There simply needs to be some finding that the property was in disrepair and that the landlord could have been on notice. They do say if the disrepair was not observable in any reasonable way, for example, damage to foundations or something, it's a bit different. But if the landlord could have been on notice, then the landlord will be liable for damage caused to third parties. The thing is here, Ring and Cohen is very clear on it. This is specifically in relation to highway cases, not just to neighbouring property cases. Mint and Good, similar situation. But here the point about whether this very strict liability applies to neighbouring property cases was considered. And you'll see there, a little bit unfortunately, Lord Justice Somerville took the view that it was not, this strict liability was not confined to highway cases. Any neighbouring land could be relevant. Denning took the view that it was confined to highway cases and wouldn't go any further than that. And Lord Justice Burkitt helpfully agreed with both. So not particularly clear how far this stricter liability goes. In Brew Brothers Limited and Snacks, similar sort of setup again, but here the Lord Justices took the view in concert with one another that actually there was no reason that that strict liability ought to simply apply to highway cases, and that it could go further to any kind of neighbouring land case. So that would, on that interpretation, apply to the case, the hypothetical case here. But that observation was totally obiter. And that's the end of the story. We've not had anything really that answers the question. So my position in cases I deal with is always that, yes, if there is a repairing obligation that the landlord owes to the third party and it's been breached, then that can carry over to tenants, to the claimant tenant, and that the position is simply analogous to Section 4 of the Defective Premises Act. I'm being told in no uncertain terms that my time is now up. These slides will be going out at a point in the future. The point that you might be interested in looking at in your own time is going to be my responses to that original set of particulars, I've set out in quite a bit of detail what I would be saying in a defence where nuisance is raised. But hopefully that has touched on at least what is quite a tricky situation and highlighted that it's not quite so simple as it might seem.
Right, ladies and gentlemen, David appears to have frozen. I promise I've done nothing unpleasant to him via the technology. Position now is the next speaker will be Harry Nuttall, who will be addressing you very shortly. Those of you who've got this on video will have observed an additional panelist join us in the course of David's talk. She is the individual without a beard or glasses. It's Queenie Jan. Queenie has just joined Chambers. She had a very impressive pupillage and people speak well of her. Those of you who haven't met her or instructed her thus far, I strongly recommend you do so. If you have questions for David or indeed Harry, if you could send them on the chat link direct to Queenie, what she will then do is collate them. That rather avoids us getting 27 versions of the same question that have to be responded to sequentially. So any questions you have for David, if you send them through to her now, and then obviously Harry's as you go along. So I will now hand you over to Harry. Lurk in the background until I start sending him stroppy direct messages saying your time's up, matey. Thank you.
So for those of you that don't know me, my name is Harry Marriott. I have been a pupil in 2018. I completed my pupillage at St Ives Chambers. Since 2019, I have been a tenant. I do housing cases along with business and property. David has very helpfully given us a summary of the relevant substantive issues. What I intend to do is to look at the more procedural aspects. And in particular, I wish to look at two elements of procedure, the cradle, that is pre-action protocol, and then the grave, which is costs. Again, much like David, I want to do this from both a landlord and a tenant's perspective. Regardless of whose perspective we are looking at, damages are very much half of the story in disrepair claims, of course. Unless costs are considered at the same time, we only have half of the picture. So hopefully what we should see today is how we can move from the pre-action conduct process and set ourselves up best to achieve the best costs outcomes. What I don't intend to do today is simply parrot the provisions contained within the relevant pre-action protocol. You all can read, and I'm sure that you all have already read it. And what I will instead do is just focus on a few key aspects. Given the time, I intend to power through the slides at the start. I've included some relevant links. You can, of course, peruse those in your own time. A couple of things that are probably worth noting as we start going is there is no longer such a thing as a pre-action protocol for housing disrepair cases. That very much went away with the implementation of Section 9A of the Landlord and Tenant Act. What is not a good start is not referring to the protocol properly. You've seen the name there. I don't intend to parrot it every time I refer to it. I'll just call it the protocol for the purposes of today. Everybody will, of course, be aware that the protocol is very much a call and response approach. There is first the tenant setting out the nature of their claim and then the landlord responding to it. And that's what I particularly want to focus on in the first aspect of these slides. But before we get on to that, I think it's probably worth looking at the purpose of the protocol, and particularly paragraph 1.1. That is very clear that the protocol is intended to be used for claims where the landlord is aware of the conditions. And that notice point is very significant. From a tenant's perspective, we want to be bottoming that out before we issue. But then those acting for a landlord may wish to just make a note of paragraph 1.1. It's a very helpful paragraph to just dismiss claims and come across as robust when we're faced with allegations of defects where there's no evidence at all of the landlord having prior notice. This slide about cases which are suitable for the protocol, I don't intend to particularly go into in any detail. You'll all be aware of these types of cases, and David has very helpfully given us a summary of a number of those causes of action. We probably should spend a very brief time looking at the cases that are not suitable for the protocol. The first point relates to the interplay with prosecutions under Section 82. The facts that give rise to these prosecutions almost certainly give rise to civil housing condition claims as well. And it seems to be quite common that letters of claim will chuck in a reference to a prosecution as well. There is no place for that. The protocol is very clear, it is not the avenue. I imagine this probably stems from the idea that chucking more into the letter of claim will make it appear stronger. In my view, this is very much a case where less is more. The scattergun approach does nothing but make the claim appear disparate and messy. Those acting for landlords may again wish to make a note of this. It is a significant point to raise. The second point there is a somewhat obvious one. Housing disrepair claims starting from counterclaim or set-offs are not required to follow the protocol, and I don't think we need to go into much detail as to why that is. The third point is a somewhat more interesting one, and it relates to the interplay between housing condition claims and personal injury claims. We'll go on to discuss this in a little bit more detail later on, but one should be aware of that interplay. If there is a concurrent personal injury claim that requires expert evidence beyond a GP letter, we want to be using the personal injury pre-action protocol for that aspect. I think these sort of cases will be very few and far between, but it's worth noting. If the personal injury is minor in nature, we don't need to concern ourselves with that. As I've said, I really don't think there's much value in me just parroting the provisions to you. What I instead want us to do is spend some time looking at how we can craft the perfect letter of claim and the perfect response to claim. And I think the way that we can do this is by effectively forming two checklists. So we have a checklist for the letter of claim and we have a checklist for the response. Now, hopefully, if we follow that checklist, we should have a fully compliant document. But equally, for those of you that tend to represent just landlords or just tenants, having a copy of the opponent's checklist, as it were, should help you flag any issues. If we start with the tenant, firstly, the claim farms approach, as it were, that is effectively the case of pile them high, stack them cheap. Or in the alternative, we can, speaking frankly, do it properly. I think it's quite obvious we need to approach this from the proper approach. I understand the temptation of trying to deal with these letters of claim cheaply and quickly. But in my view, if we present this claim as strongly as we can from the inception, it is likely to lead to the best outcome for tenants. Equally, for those representing landlords, it is somewhat of a gift if the letter of claim is approached poorly. The first thing we should probably note is that there is no prescribed form for a letter of claim. What there is, however, is an example precedent letter of claim at Annex A of the protocol. The annexes are actually very useful. I think they're things that are generally glossed over. We will look at these annexes as we go through. But in my view, if you've got a little bit of time, it certainly is worth exploring them. Annex A, as I say, is the precedent. To avoid the possibility of errors coming in, it's probably worth starting with that precedent and then adapting as appropriate. I don't think I need to dwell particularly on the basic information point that's set out there. That information is quite obvious. The one I will probably flag as significant is the requirement for the tenant to set out when access will be granted. That is one of the themes that we'll come on to discuss in some more detail, and the significance of the tenant allowing access will be highlighted. The defects should also be set out in the letter of claim. That is probably quite obvious. Again, have a look at Annex C. That sets out a schedule for you to detail the defects. I think it is incredibly helpful to have that in mind. It very clearly sets out the constituent elements of the claim. It does require a little bit more work to use that schedule properly, but in my view, it very much is in the interest of the tenant to do so. At some point, the case is going to have to be set out properly. We might as well do it properly from the beginning. For those for those acting for tenants, if you can't fill in the gaps at Annex C, you can't make out all of your claim, and so there's no point trying to pursue it. Again, given the time on this point, I think we can move quite quickly through it. In broad terms, the letter of claim needs to set out the claimant's case. This is often done in a very lazy way. I think a lot of people would agree. Very vague phrases, such as "on occasions too numerous to particularize" or "since shortly after the commencement of the tenancy," don't help. If a tenant doesn't have a case on notice, a tenant doesn't have a case at all. I've already touched upon it, but the need to grasp the nettle early is key, and to set the case out strongly from the outset is likely to be the best approach. Just note from a tenant's perspective, if these vague assertions are being used in the letter of claim, I would be jumping all over it in the reply. I would make a real issue on this issue of notice in particular, and this can feed back into paragraph 1.1, which we flagged and discussed right at the start. When looking at the third point down and the effect on the tenant, this links back to this idea of an interplay between personal injury claims and housing conditions claims. We often see in letters of claim that there is a passing reference made to a personal injury. It may be the exacerbation of a cough caused by damp, for example. For those acting for tenants, I think this is a very difficult issue to grasp, and it can be somewhat of a double-edged sword. One must be mindful of the effect of Section 11.2 of the Limitation Act, and that effectively says if there is a personal injury claim, the 3-year limitation period will apply to the entirety of the claim and not just the personal injury aspect. As we've already touched upon, there is always this temptation to try and add in more. The logic being the more that is there, the stronger that the claim is. But as I say, I think we need to think very carefully about this. Is pursuing a personal injury claim worth sacrificing this limitation point? I think it's very unlikely that the additional damages of pursuing a personal injury claim, where it is just no more than a bit of a cough, that is unlikely to warrant losing a potential 3 years of liability for. That's very much the tenant's perspective, but let's look at it from a landlord's perspective as well. Let's say the letter of claim does contain a passing reference to a cough caused by damp. I think we need a robust response to that. I think we need to invite the tenant to set out if they are pursuing a personal injury claim, invite them to provide the basic elements of the claim, but then also flagging this issue of limitation. It very much does give rise to a possibility of effectively cutting the claim in half straight away. Special damages tends to be an issue which is also approached very poorly. Annex D, again, provides a very useful tool to adopt. It is effectively a schedule where the tenant can set out their alleged special damages. A point that's worth noting is for some time it has been established that general miscellaneous expenses, which are entirely undefined, are not recoverable. There is no point making reference to them. In my experience, special damages tend to be approached quite poorly in letters of claim. It tends to be no more than a single sentence saying special damages are being explored. Again, let's flip this on the head. Let's look at it from a landlord's perspective. What do you do if you're met with such a vague document? I think I would be inviting clarity. I think I would even be sending a copy of Annex D to the tenant solicitors and saying, when you set this out properly, we will respond. The final point to note is that of letters of instructing an expert. Again, Annex B contains a useful summary that's probably worth looking at in a little bit more detail. Disclosure is a process that starts at this pre-action stage as well. I've detailed there a list of the relevant documents that can be requested at this stage. These are set out in the protocol as well. These are largely obvious. Just note, the protocol doesn't contain a carte blanche for disclosure of everything. It is confined to that which is relevant. For those acting for a landlord, you are likely to get far-reaching disclosure requests. Just think about the value of fighting that disclosure request. You don't want to be faced with an application for specific disclosure and the costs that follow if it's likely that disclosure will be ordered in any event. I've also included at the bottom just that general point to note. Having had a look at the list of delegates, I think it's very unlikely that we have any landlords here who won't have access to the protocol. So I think we can skim over that. What we then turn to is the landlord's response. And again, we've got this next checklist that we want to be working through. Just note again, the landlord's response is precisely that. It's a response. It's going to be reactive to the letter of claim. And we need to use the checklist that we've just gone through to see if there's anything that we need to respond to or anything that we can point out as a failing. There is this issue of timing. It is very clearly set out in the protocol that the response should be sent within 20 working days of receipt. One thing that I would note at this stage is that there is no cause of action created by non-compliance with the protocol. It is, however, relevant to the issue of costs. And that's what we'll be coming on to look onto in the second aspect of the talk. So trying to meet this deadline is key. We've largely touched upon this issue of disclosure already. Given the time, I don't think we need to go through that again. Experts can't be glossed over. There needs to be a response to the suggestion made by the tenant. Again, Annex B is a helpful letter of instruction. When we are responding to a tenant's draft letter, we want to be comparing it to Annex B. That may well provide us with reasons to object to the suggestion. The response, of course, needs to address the substance of the claim. And I think we can start to tie in some of David's themes that he's told us about. When we are looking at the substance of individual allegations, there is, of course, the ability for the landlord to make admissions at this pre-action stage. Now, some landlords may take the view that there is little value in making admissions at this stage. They may well wish to keep everything in play. The failure to make admissions does not prevent separate without prejudice offers being made. Now, when responding to those allegations, what I have set out at point 2 are 5 key questions. They very much reflect Annex C and the schedule that a tenant can produce. And in order for a proposed claim to succeed, we need to answer yes to every single one of these questions. Now, I appreciate that there are a very large number of disrepair claims which are facing a number of landlords, and there therefore can be a temptation to be lazy if we get no to one question, we don't bother to go on to the remaining 5. In my view, that's not a good approach to take. I think we want to be setting out the weaknesses in relation to the claim at as many stages as possible. The more elements that we raise objections to, the stronger that the defence appears. It is probably worth discussing this issue of access at this stage. And if the landlord's case is that the tenant has failed to allow access, we want to be setting this out in the response, and we want to be providing dates. Now, I think this is a point that we really want to magnify. There is likely to be an express term in the tenancy that access should be allowed. There is certainly an implied term at section 11.6, and a lot of these causes of action are essentially contractual ones. The tenant remains under a duty to mitigate her loss, and by failing to allow access, they have failed to do so. What I have seen in a number of letter of claims is this reference to a landlord doing works amounting to a breach of the pre-action protocol, and therefore an injunction would be sought to prevent the same. Speaking frankly, this is a nonsense. Breach of the pre-action protocol does not give rise to a cause of action for an injunction. And from a landlord's perspective, I would be robustly replying to any suggestion that there is. Again, I think we want to be effectively saying it is noted that the tenant's position is they will not allow access. That is a breach of the terms of the tenancy, both express and implied, and that is a failure to mitigate loss. The contents of this slide won't act as any surprise to people. The landlord is required to set out clearly their case on works, compensation, costs, and limitation. It is probably worth addressing this aspect of alternative dispute resolution. This is going to be relevant to the issue of conduct and therefore costs that we are about to discuss. An approach and responses that I've seen that seems to be quite nice is containing a link to the Civil Mediation Council's website and saying to the tenant, suggest some mediators and we will consider. So that is the pre-action aspect that we want to talk about. Hopefully by using those checklists, we can ensure that our clients' responses to the pre-action protocol stage are perfect, and we can pick holes in the approach of our opponents. Now we've discussed the cradle, let's move on to the grave and let's look at costs. I'm sure a lot of you, costs are the most significant thing you are looking at in relation to disrepair claims. And as I've said, this needs to be looked at not just by landlords, but also by tenants. The general cost provisions, all of you will of course be aware of. Again, there is no point in me parroting those. I've included some of the factors there that parties will look at in considering costs orders. And in my view, to obtain a favourable costs outcome, whether acting for landlord or tenant, there is a three-pronged approach that we need to be going. That is linked not only to conduct, the first factor there, but it will also be linked to the scope of the claim. If we can kill off a number of aspects, or if we can strengthen a number of aspects in the pre-action stage, we're going to be hopefully obtaining more favourable cost outcomes. The second thing we need to be looking at to obtain favourable cost outcomes is allocation. And the final thing we need to be looking at is offers. So we've already talked about pre-action conduct, so we can move on from that. What we want to be talking about next is allocation. From a landlord's perspective, if we can get a small claims track allocation, we are getting a minimal costs order. Equally, from a tenant's perspective, if we are getting a fast track allocation, we are opening up greater costs orders, subject, of course, to those questions of reasonableness and proportionality. What we want to be looking at here is the interplay of a specific performance claim and damages. I've included the relevant provision when it comes to allocation on the slide. I'm sure you're all familiar with it, but essentially if a tenant can make out a specific performance claim worth more than £1,000, we're being more likely to get a fast-track allocation. From a landlord's perspective, a very simple way of avoiding that and getting the costs down is to defeat the specific performance claim. Now, if that is done early and there is no specific performance claim, there is nothing for the court to trouble itself with when it gets to the allocation stage. On this point, evidence will be key, evidence that the outstanding works have been done, and potentially evidence that the tenant has frustrated those works being done. This links to a recent case on valuation, which is probably worth noting. It's the case of Jalili and Bury Council. It's only a county court decision. It's not a binding authority. The judgment can be very easily found online. A couple of months ago, it made its way through a number of prominent blogs. The thrust of the judgment essentially is this. A specific performance claim requires the landlord to do the works, and so the cost to the landlord of doing the works is the relevant factor. The open market cost of doing the works is an irrelevance. Now, that's quite a useful case for landlords to have in their back pocket to highlight how it should be the costs identified and estimated by their surveyor rather than the costs of the claimant surveyor when it comes to assessing the value of any specific performance claim. But as I say, this is only a county court decision. It is not a binding authority. I've raised it in a couple of cases recently. It sometimes seems to gain traction, it sometimes doesn't. It's probably worth noting that allocation to the small claims track is not the end of the story. We have the case of Birmingham City Council and Lee. Most of you will no doubt be aware of that case. I think it is worth reading the judgment in its entirety. Essentially, it says that if a claim was a fast-track one at protocol stage and works were then done to defeat a specific performance claim, the tenant can recover fast-track costs up until which the date of the works were done. Note that the tenant should apply for such an order at the allocation stage. It is a little bit on a tangent, but I think it's probably the most convenient place to mention it, and it's about the timing of cost statements at point 3. It's a slightly ancillary procedural point, but be aware of Practice Direction 44, paragraph 9.5. If you are dealing with a fast-track case, the N260 should be filed and served no later than 2 days before the hearing. In all other cases, no later than 1 day before. It's not uncommon that these deadlines are missed, but I have included at the bottom of the slide a High Court authority where the court took the view that the failure to comply with the practice direction meant you'll be getting no costs at all. It's a harsh rule. I imagine that we would struggle to convince a number of courts to follow that reasoning, but it's one worth knowing, and should it arise, it can be included. So we've discussed pre-action conduct, we've discussed allocation, and now we need to discuss the issue of offers. The consequences of a Part 36 offer will be known to you all. There is no value in me going through Part 36 in any detail, but you may well think that this is the best weapon in the arsenal, whether you be for tenant or be for landlord. It is going to be a pretty brave opponent that is going to ignore a well-placed Part 36 offer. A significant point is a well-placed Part 36 is going to need to follow an objective, rigorous that is so high that even if liability were to be found, the defendant would recover far lower damages. Equally, there is no value in a defendant making an extremely low Part 36 offer that the claimant will easily beat. So that rigorous analysis really needs to be done, and one needs to look at the case objectively. I have highlighted a couple of points which we'll just gloss over. You can't use, and the cost consequences of Part 36, won't apply if you don't comply with the procedural requirements. They're quite rigorous. It's quite easy to get it wrong. The safest approach might be to use the pro forma that appears in the N242A. Secondly, the cost consequences at Part 36 don't apply on the small claims track. If you are representing a landlord and you get that small claims track allocation, you're slightly likely to be less worried about that Part 36 cost consequence. Note, there's nothing to stop you making Calder Bank offers on the small claims track. One thing that I think we really need to emphasize is timing. And timing is key when it comes to these offers. The cost consequences will only bite after the expiry of the relevant period. So what we want to be doing then is making well-placed offers early on in the litigation. A fixed cost regime is, of course, coming for housing disrepair cases. It was announced a couple of weeks ago. I'm sure you've all seen it online. This follows the Jackson reforms, which were initially raised in 2017. There has been, hopefully, a 4-year delay in us getting to where we are now. I imagine the issue of COVID has slightly put it on the back burner. But we do now know it's coming in. We don't have a date for implementation yet, as far as I'm aware. And it's also not entirely clear if it will only apply to new claims after the implementation date, or if it will have retrospective effect to existing claims. I would be very surprised if it had retrospective effect, but we don't know for sure yet. The response to this seems to have been somewhat mixed. There has been a lot of debate about what effect, if any, will be had by this. We will discuss what the costs will be under the fixed cost regime. They are likely to be considerably lower than a tenant could be reasonably expected to recover now. Now, what that might mean is that there's no money left in doing tenant work, and so these claims will just die a death. A converse view that seems to be forwarded as well is that instead it will just lead to corners being cut to ensure that there's still some profit in bringing these sort of claims. There's a couple of key points to note. There'll be an expanded fast track to intermediate cases between the value of 25,000 and 100,000. There will also be banding within that to dictate the amount of costs that can be recovered. All cases will be allocated to one of 4 bands based on both the damages claimed and the complexity. And the more so of each of those, the more costs that can be recovered. One of the things that's also been raised is this idea of a penalty, £150 for a party that argues for allocation to a band and does so unsuccessfully. Clearly, that is intended to be a deterrent. If it has that intended outset, I don't know. £150 is not a considerable sum of money. A lot of people may take the view it's worth the risk of running the argument. And if you're unsuccessful, you take that relatively small penalty. Note, whenever there are fixed cost cases, there are questions of how we get out of it. And there is definitely going to be an escape clause for what are described as exceptional cases. We're not entirely sure what that means, and hopefully there'll be some clarity soon. What I've included here is the table of the costs which are being proposed under the fixed cost regime. This is quite old now. It doesn't take into account inflation. There's been a fair few years of inflation since this was originally drafted, so these figures are going to go up a little bit. And we don't know when this will actually be implemented, so we'll have inflation going on between now and then as well. You will see that there are almost no costs to be had in the band 1 cases. We need to be moving into bands 2, 3, and 4. There are also very limited costs to be had in the early stages. We need to be moving into the post-issue and the post-allocation when costs really seem to be going on. What I don't think is of much value is placing too much weight on this before fixed costs are implemented. I don't think any tenant, solicitors acting for tenants will be particularly keen to adopt settlement on these terms prior to it being forced upon them. Offers as to costs which are calculated in accordance with this table are very unlikely to be accepted. The other thing that I think is worth noting is the move between post-listing and trial. The amount of costs which increase between those two stages is very limited, save for in the most serious cases. If settlement can't be reached under the fixed cost regime before listing, a number of landlords may well take the view it's worth taking the risk, we'll run the trial and we see what we get, given that fixed costs won't accrue that much more. Just a point worth noting preemptively. So inevitably, when those figures are so low, there are going to be questions of how we can get them lifted. How can we escape those limited costs? I've set out the main avenues there, and I've set out them broadly in increasing order. There is an uplift which is proposed for those representing vulnerable clients. Vulnerable is currently unidentified. Hopefully we'll get some clarity by the time these fixed cost regimes are implemented. Unsurprisingly, there is an uplift for those where a party is living in London and those who instruct lawyers living in London. There is a 25% uplift for each additional claimant. In my view, that's quite generous. The facts that make out the claim are likely to be in no way different, whether you have one claimant, two claimants, or three. So that's quite a significant one to note. The effect of Part 36, as we discussed, is significant whether it's fixed costs or not. On the fixed cost regime, we'll be looking at a 35% uplift. But the most significant uplift is reserved for unreasonable behaviour, that being a 50% uplift. So this is going to highlight how even when fixed costs come in, it's so important that our conduct is squeaky clean from day one. We need to be complying with the pre-action protocol. We need to be doing everything by the book. One of the things which has been specifically raised and hinted to as potentially amounting to unreasonable behaviour is challenging an allocation or resisting such a challenge without sufficient cause. Now, when I said earlier that that £150 penalty might not be enough to deter people, perhaps this 50% uplift will be a bit more significant. But note it's sufficient cause, so that's quite a high test, I would have thought. Well, I appreciate that's somewhat speculative. We don't entirely know where the position will come in, but we certainly know it will. And I'm hoping that that rough summary of both the start and the end will assist you both in the cases moving forward that you're dealing with. And I think on that note, I'll hand back to Michael and I'll stop sharing my screen.
Good afternoon again. Both very interesting, and I think David with actually refocusing on what the obligations are rather than the all too common well, it's damp approach, which is something from which the judiciary are not immune, and very often a judge has to be taken carefully through it to have it pointed out to him or her that yes, it may not be a nice place to live, it may not win the Ideal Homes Award, but that doesn't necessarily mean that that is actionable. Harry too, I think raised some very important points. I know there are some questions to come. I'm going to chip in a couple of things. The issue of access and particularity, if you are denying access just as if you're on the other side and asserting complaints have been made, particularity is key. It is of little use to say, oh, the tenant on numerous occasions has not let us in. Well, you know, did she slip out for 5 minutes for a pint of milk? Was she actually flicking V through the front room window? Or were the workmen just about to knock off for the day and simply shoved a card through and ran? As with making complaints about, on occasions too numerous to particularize, if there are two matters there. Firstly, if your client has only told you of half a dozen occasions and can't think of any more, then I'm afraid they're not too numerous to particularize. There were 6 of them. They may not be able to give the exact dates, but generally speaking, people can be guided to dates. You know, was it before or after your child was born? You know, was it before or after the kids started school? You know, was it near Christmas? Was it in the school holidays? You know, if you can say in or about August 3 years ago, that's good enough. By the same token, and I notice I'm sort of slightly anticipating one of the questions, you know, what if the council's repair records then show more than your client actually told you about? The answer to that is when you put in your particulars on the information available to present, the claimant is able to particularize the following instances. Claimant's position is reserved pending disclosure. That way, you can always come back and put additional matters in. The council or landlord simply can't say, oh, we didn't know about it if it's coming from their records. Another one which was raised by Harry, and I think this is important, is the whole issue of refusal of access because you haven't told us what works you're going to do. And unless you do, we will seek an injunction. The first point, of course, is that the protocol does not confer that right. What it does at 6.3d is provide that as part of the landlord's response, the landlord must set out the works it intends to do, its anticipated timescales and start dates. It doesn't then confer on the tenant or his or her advisors the right to veto those works, seek additional works. If additional works are wanted and the landlord isn't going to do them, your answer is to sue on the tenancy agreement and or seek specific performance for those additional matters. All too frequently one sees in letters of claim the assertion that if you don't provide us, you're not to carry out any works unless we've agreed to them. Well, and if you do, we'll seek an injunction to stop you. As Harry said, that's a nonsense. Actually, the person then who should then be seeking an injunction is the landlord. The tenant has breached the terms and conditions of tenancy. Furthermore, if it's done on the advice of their solicitors, the solicitors themselves can be named as a party for procuring a breach of contract. That's quite attractive because you can potentially seek a costs order against the solicitors on any pre-action injunction. If they have told their tenants, you must not do this, and obligingly set that out in a letter of claim, and the tenant then follows that advice, the tenant's advisors are squarely in the frame for a costs order, and going on from that, perhaps the fixed predictable costs, I think that probably would be unreasonable behaviour, and so open yet another door. What I'm going to ask the panelists to do is to unmute their mics so that we can all chip in. Obviously, certain questions have been addressed to certain people, and perhaps if Queenie has passed them on, I think she has from what I've been monitoring, if the individual to whom they were first addressed responds, and then if either myself, Harry or Queenie have either additional or conflicting responses, we will chip in.
Thank you. Quite a few questions have come through during that webinar, and I thought it might be good to start with a question from Matthew Lakes. And he asks, do you consider it an abusive process to simultaneously issue a civil housing conditions claim and a Section 82 Environmental Protection Act criminal complaint, relying materially on the same facts and seeking materially the same remedies, i.e. repairs, damages and costs? And he also adds, if so, does that warrant an application for strikeout, summary judgment, dismissal in respect of either claim, leaving only one set of proceedings alive? Or would it be more appropriate to stay one or other claim and merely argue over costs at a later stage?
So I think this is probably a question that's arisen from my aspect of the talk. I think the thing that's worth noting, first of all, is the test for an abusive process, particularly in relation to strikeout, is a high one. there's some quite useful commentary in the White Book that you may find worth reading. There's no particularly defined points, but it's a nice background if you want to have a look into it. I don't think that's the approach I would take. I don't think I would apply for strikeout. I don't think it would succeed. What I think is instead key is if you're faced with this letter of claim that sort of hints at an Environmental Protection Act, I think a very robust landlord response is required. I think it's important to make it clear that you don't consider that to be a valid notice of intended prosecution, and then see where we go from there. I don't think you can necessarily kill it. If they then want to comply with the notice of intended prosecution and send that to you separately, then that's a matter for them. What I do think is significant there is very much starting to paint this narrative of non-compliance with the pre-action protocol right from day one, setting out how the requirements of the protocol are clear, the reference to the EPA prosecution being an irrelevance, and if you want to do it properly, we await your notice. I don't know if David or Michael disagree with me, or if there's anything particularly they wish to add following that.
I'd say that I think statutory nuisance under the EPA is sufficiently different in terms of what's needed to be than a Section 11 breach or even a fitness for human habitation type claim. I think they're all sufficiently different that you could sustain all of them at the same time without any being an abuse. In terms of what you do about it, though, yes, I think there's probably a pretty substantial costs argument if the remedies that are being sought in all of the different actions are the same. And I think you'd probably, again, assuming the remedies are going to be the same, you'd probably have a pretty good crack if you wanted to at applying to stay the civil claim under paragraph 11A of the practice direction to part 23, specifically provides where you've got concurrent criminal and civil actions going on which arise out of similar facts. I think you'd probably be looking at doing that in that sort of situation rather than facing the two claims or two actions at the same time. I think that's probably what you're limited to, unless Michael has any good ideas to the contrary.
No, David. In fact, there's authority, not exactly on the point, but would be highly persuasive. It's the case of ESA, and I think it's Hackney. It's certainly one of the London boroughs, where somebody attempted to plead cause of action based on a conviction for statutory nuisance. And the Court of Appeal said, well, quite ingenious, but you're dealing with quite distinct legal concepts. And indeed, the remedies for the same set of facts can be quite different. The classic one is damp in the property, condensation dampness, let us say, where there is no defect, it's a design defect. That is actionable for a Section 82 prosecution. It would not have been for Section 11. And there is a difference between unfit for habitation and prejudicial to health. There is specific provision within the EPA that says where they recognise somewhere as prejudicial to health, they can make more far-reaching, sorry, not prejudicial to health, unfit, they can make more far-reaching orders. So prejudice to health is plainly a slightly lower hurdle to surmount. They are different, the remedies are different things can be sued upon. Often, of course, they are perfectly common, but I don't think it's an abuse, nor do I think within a letter of claim it is necessarily abuse to say, in addition, we write to inform you that we regard the premises as prejudicial to health, and we will advise our clients as to whether or not to bring a Section 82 prosecution. The reason for that is, if you fail completely in a prosecution under Section 82, you will recover nothing. And you will have incurred the costs probably of an expert, certainly of a couple of hours of legal advice as a bare minimum. In a case called Hollis and Dudley, which now goes back more than 20 years, the divisional court said it was entirely legitimate to issue on the 22nd day after giving notice, because 21 days had intervened, because otherwise the risk was the landlord would do the works and you would be out of pocket. So I think one can take from that, it's not an abuse to stick to time limits. It's unlikely to be an abuse to bring a claim or a prosecution where the facts exist. I do agree with David that where there are concurrent civil and criminal, the civil ought to be stayed pending the outcome of the criminal, because otherwise, in addition to the matters set out in the civil procedure rules, there are Article 6 considerations. If you are compelled to give evidence to defend yourself in the civil claim, you may be making admissions or asserting a case that will then be relied upon against you in a criminal prosecution. And although EPA claims, walk like a duck and quack like a duck, or at least sound very like civil claims with experts in court, exchange of witnesses of fact, they're not. At the end of the day, they're criminal. So I do think it would be legitimate. And I think any sensible tenant advisor, when faced with the suggestion that the civil ought to be stayed until such time as the criminal was resolved, would be well advised to accede to that. Simply, and again, a failure to do so might well be unreasonable.
Thank you for those helpful answers. The next question is directed at you, David, from Brendan Ryan, and it's regarding whether you could give a view as to whether external render would be considered part of the structure.
Yeah, I don't see why it wouldn't be, for the same reason that plaster on the interior would be part of the structure. External renders doing the same job. It's both adding a semi-structural finish, and it's decorative, but not just paint. There's plenty of case law on cladding and how decorative cladding is part of the structure. And I'm not sure why render would be particularly different. Now, I'm not going to suggest that I have been following every single first instance decision of every district judge and circuit judge, and there may well have been some situations where the judge has found on a given case that external render isn't part of the structure for some reason. But I think the starting point needs to be that it is, unless there's something quite peculiar about the construction of the property.
Thank you. The next question is directed at you, Harry, and it's from Ben Stevens, and he says he's recently had a tenant solicitor argue that the list in paragraph 5.2 of the protocol is essentially optional, as he says it should contain rather than must contain, and he's wondering if there's any merit to that.
Well, it's a bit of a difficult one, that one is. It does contain should. I think it's more of a best practice point. I mean, the fact that they're not providing a phone number, I think you go on to say in your question, is just madness. I think in that case, I would be highlighting the deficiency. If they want to come back on it and say, well, it's okay, well, then so be it. It's very much an argument for the end. It's an argument for costs. I don't think it's a killer point for your client, but it's a point that can be made. With reference to the failure to provide the phone number, which you go on to describe, and it's causing issues with arranging an inspection, I think with that one, just be aware of what Michael has already touched upon. Is there a possibility that an injunction would need to be sought down the road? I don't think you're quite at that stage yet, but if there's continuing problems and continuing breaches in getting those works done, that might become relevant. I don't know if anybody else has anything they wish to add.
Very briefly, I mean, yes, it's not simply a matter of semantics, should and must. Should indicates it ought to be done if possible. Now, clearly, if it isn't possible for some reason to tick some of those boxes, the information's not to hand or whatever, they shouldn't be penalised. On the other hand, if it's just, well, it's Thursday, so we're not telling you, or the client doesn't like the inspector, so we're not telling you, I'm afraid that probably is unreasonable and may well be a breach of the protocol. You know, and both landlord and tenant advisors are guilty of this, saying, you know, you're not complying, and you really do need, in those circumstances, to look at your own stance. I mean, a particular favourite of mine is a firm that regularly pleads several paragraphs dealing with non-compliance as part of their standard particulars, and then asserts the claimant at all times has complied with the protocol. And there isn't even by that stage a schedule of special damages, which is just a complete open goal, because the defence goes in and says, you haven't complied with the protocol. Where's your schedule of specials? Doesn't appear in this document, didn't appear on the letter of claim.
Thank you. We have another interesting question, which states that the practice direction, pre-action conduct and protocols mentions at paragraph 2, a person who knowingly makes a false statement in a pre-action protocol letter or other document prepared in anticipation of legal proceedings may be subject to proceedings for contempt of the court. They state that sadly, this is not included specifically within the housing protocol, but is it still worth citing, or is there something else that is similar that can be cited in its place?
Well, I would have thought all of the pre-action protocols are created under the practice direction on pre-action conduct. And so what it says there would be applicable to the pre-action protocol, to the housing conditions pre-action protocol. That's my gut feeling about that. And certainly in terms of corresponding with the other side, there's no reason not to be banging that particular drum. I don't know, Michael, do you have any other views on things that can be done in this?
I think it certainly can be done, because the practice direction is, I agree with you, an overarching enabling provision and of general application, even if there is no protocol. That said, do be careful that, you know, you may be pulling the pin from the grenade. Accusing a professional of contempt of court is not something I would do lightly, because they can legitimately say this is an allegation of serious professional misconduct. It impacts on our reputation. It might well lead to applications to disbar or remove from the role, because you would have to notify your regulator if you were found liable for contempt of court. There would be considerable reputational damage. What you may well find if you go down that route, and certainly if you issue, is that they will defend it robustly. And I have seen in not quite this case, but a very similar one, these solicitors put a silk in, and the judge found that the conduct concerned was not, didn't amount to contempt, and suddenly the rather aggressive party on the other side found themselves facing the bill on an indemnity basis, because they'd made allegations of professional misconduct with very little foundation, and that included the day's fee for a silk.
Thank you, that's really helpful. There's only 10 minutes left, so I'll just squeeze in a couple of more questions, although I can see there's more coming through in the chat. The next question is one, but essentially breaks down into two. So I'll firstly ask, if the tenant refuses access to complete a repair pre-letter of claim, does that absolve the landlord of liability if the tenant then goes on to include that disrepair in the letter of claim?
The answer to that is, I think, to be found in English Churches Housing Group and Shine. An unreasonable refusal of access stops the liability clock. It presses the pause button. If you then get a letter of claim, say, including this, the 6.3 response should say, well, your client's previously refused this. Are you now saying that your client is prepared to allow access. And if the answer is no, well, the clock stays paused. If it's yes, it only starts running from the point they say yes.
Thank you. That's really helpful. David, is there something you'd like to add?
Well, yeah, just the way I always look at it, and it follows what Michael says, is that a failure to grant access in no sense extinguishes the landlord's liability, but it raises various defences in terms of the clock not ticking through various mechanisms. One being that, of course, liability for disrepair doesn't kick in until the landlord's had a reasonable period of time to carry out the disrepair with reasonableness, A, the burden of showing that being on the tenant, and B, the court taking into account all the circumstances. In circumstances where the tenant isn't permitting access for the repairs to be carried out, I would be saying that's a pretty big factor in assessing how long the landlord has to carry out the repairs. B, it would obviously be a failure to mitigate loss. So whilst the liability isn't extinguished, it's met by a failure in the duty to mitigate of a like amount. C, it could be argued that it's a breach of the implied term in the tenancy, not to frustrate the landlord's ability to carry out its own obligations. And so you've got that as well. D, it would be a breach of the obligation to permit access with the damages that would arise due to that breach, equaling any sort of disrepair claim the tenant might have. So various ways you can bring that in.
Thank you. And in relation to the first part of that question, the second part was, what effect does the tenant refusing access during the period after receipt of the letter of claim have on the parties?
It's the same point. It's that when it comes to drafting the defence, then you've got a point to raise in the same sort of terms.
Great, thank you. And I think this might have to be the last question. And it states, what is your opinion on requesting wet signatures before disclosing the housing file? Is it a good defence to a subsequent application for pre-action disclosure?
I'm going to leave that one to Michael.
There is a fair bit flying around on e-signatures at the moment. I wouldn't, for a respondent, want to assert that as my primary case. In April last year, defended a local authority on a failure to comply with a disclosure order on time. It wasn't that they didn't comply. And the reason was, yes, you've guessed it, most of their staff were working from home. They were in the early days of setting up remote working facilities for the staff. And indeed, in some cases, the records were in locations that had simply been locked because the local authority concerned did not want their staff going in and out and lots of people mixing. The judge went berserk at the other side and told them if they thought in the midst of the most serious public health memory and living memory, that he was going to order a landlord or penalise them for not putting their staff at risk, they had another thing coming. And they were sent away with a tail between their legs and a costs order. I think you start taking those sorts of technical points at your peril.
Thank you. And unfortunately, that's all the time we have for questions, but thank you very much for those immensely helpful answers.
Right. Thank you all for attending. I can see that the call of tea, supper, dinner, please insert your geographical location, has been considerable because we're now down to less than 100 attendees. As I said at the beginning, Ross will be emailing out the slides after we've held all 3 sessions. I hope to see most, if not all of you, in a week's time. At some point, we're going to try and put this video of today and indeed the other sessions somewhere where it can be downloaded. I'm not sure it's going to be YouTube or TikTok, but we shall see. Thank you all very much and good evening.
Thank you.
Thank you.